My name is Jay. I use they, them pronouns. I'm an anarchist and part of the group, the Tilted Skills Collective. Today, we're going to be mostly talking about our second book, Representing Radicals, but also talking a little bit more about our first book, A Tilted Guide to Being a Defendant, and some of the, just introducing some of the concepts in both of those books and talking about a little bit more about how we see them being applicable to this moment that we are all living through. What else did I want to say? They, them. I live right now in so-called Minneapolis, which I wanted to take a moment and state that the place that I'm living is the unceded land of the J20, Sakoan, and Anishinaabe people. Let's take a moment for that. And then I wanted to say a little bit more about the Tilted Skills Collective. As I said, we're a small collective of anarchist legal workers. I've been involved with the collective since 2017, and our work has taken a variety of forms, whether that's being part of defense committees for radical defendants directly, or conducting trainings or webinars. And then as we've talked about, we have also produced these two books, and we're going to be talking about Representing Radicals today. Jenny, I'll hand it over to you.
Hello, everyone. My name's Jenny, and I use she, her pronouns. I do not live in Portland, but that is where I am currently, and I want to acknowledge that what we now commonly call Portland is actually the traditional lands of the Multnomah, Cathlamet, Clackamas, Tumwater, Tualatin, Kalapuya, Wasco, Molalla, Cowlitz, and Watlala bands of the Chinook, and many other tribes who made their homes along the Columbia River. I am a founding member of Tilted Scales, so I've been around since its inception, which I was trying to think about recently, and I honestly can't even remember when that was. I think it was sometime in the early 2010s, maybe 2011, 2012. And I've been involved in legal and prisoner support work generally since around 2006. I've been a licensed paralegal working mostly on federal criminal cases since 2018. And I think Jay gave a great explanation of Tilted Scales, so I'll go ahead and pass it off to Lauren.
Hi, everybody. I'm Lauren Regan. I'm the Executive Director and Senior Staff Attorney at the Civil Liberties Defense Center. I use she, her pronouns, and I'm based in what is now called Eugene, Oregon, which is unceded Kalapuya territory. And I have been defending activists and suing cops and the federal government since 1997. And we specifically do a lot of anti-repression work, have defended many an anarchist in the past 18 years that CLDC has been an organization. And I'm happy to be here today and to contribute to this work.
Thanks, Lauren. I'm in charge of the slideshow, so I'm just going to move this along. So we've already talked a little bit about the Tilted Skills Collective. And Lauren, did you want to say anything more about the CLDC?
Well, I guess I'll just add that, we defend activists pro bono, meaning for free. We do federal civil rights litigation on behalf of the movement. We represent grand jury resistors. We do a lot of know your rights trainings. The website is cldc.org, and because of the last year of pandemic, we've been doing these know your rights types of webinars every week and every other week, and they are available for video replay on all sorts of topics, from police misconduct to impact litigation to grand jury trainings. So if you have some extra time on your hands and are trying to build skills, take a look at cldc.org resources, and you can request a link and password to any of those video replays.
Well, thanks, Lauren. an obligatory disclaimer that Jenny and I are both not lawyers, though we are very smart and experienced doing legal support work, anti-repression work. I don't know if I said this in my intro, but I've been involved in anti-repression organizing in a variety of capacities since, I don't know, 2009-ish. But we are not lawyers. And even though Lauren is a lawyer, this presentation, perhaps it's obvious, doesn't constitute legal advice or continuing legal education, though if we hit on a topic and you're curious to learn more about it or just want to be connected to additional resources, feel free to send us an email, and you can find our email address through our website.
All right, so we're here to talk about our second book, which we'll do in a minute, but we wanted to give you just a brief rundown and sort of explanation of our first book, which was called A Tilted Guide to Being a Defendant. And that book is sort of a comprehensive guide to facing charges in the criminal legal system for defendants. It's intended to help defendants not only figure out how to handle their legal cases, but also how to think about or sort of frame them within the context of radical movements. So rather than being a how-to guide, the book offers a way of thinking about criminal charges that is based on defendants' goals, which we sort of break down into 3 categories in the book: personal, political, and legal. And you can see on the slide here that we have this sort of Venn diagram on the cover of the book, and we use it repeatedly throughout the book as a way to conceptualize this idea of having various goals. And sometimes those goals are very related and they overlap and they seem to make sense together. And other times they can actually be really distinct from one another. So I definitely encourage everyone to check out the book, which you can download for free from our website. The book grew out of our experiences as legal workers, and all too often we were seeing the ways in which legal cases could kind of go sideways, and defendants and movements, of course, ended up getting harmed in the process. Often those mistakes were not because somebody had bad intentions, but because the legal system can be such a complicated, sort of ominous beast. When people go unprepared or without the support of people who have maybe been through it before, it can be a really daunting and scary process. And sometimes people can end up making choices that they don't completely understand the consequences of. So the book hopefully helps people sort of take a deep breath and take a step back to look at the bigger picture and then make choices about their cases that can help them advance their case, but also help us strengthen movements while we're fighting criminal charges, instead of constantly having charges tear movements and people apart. So when we first started talking about doing this book, it actually started out as a conversation about the guide for lawyers. So we were really excited to finally be able to move on to that and to bring it to you all today. So I'll let Jay talk about that a little bit, and then we can jump into more of the details.
Thanks, Jenny. Certainly that 3-pronged framework is one that we reference over and over and over again in Representing Radicals as well. So I'm going to be talking a little bit more about that shortly. But before I do, we're here today to promote our second book, which is called Representing Radicals. So with the Defendant's Guide, as Jenny explained, is written to radical anarchists, socialists, other leftists facing charges as a result of their politically motivated actions or associations. It's written to them to help them kind of conceptualize how to move through the criminal legal system. Representing Radicals is this companion book written, addressed to the lawyers who are representing them. So those lawyers may be movement attorneys who've been, through this for decades, or might be like, just not just a criminal defense attorney without experience working with this particular population of folks. So Representing Radicals, I think, highlights like some of the ways that representing a radical client would be different than maybe other criminal cases that an attorney is used to. But it also like really focuses on, has an explicit focus on how to help radical clients achieve goals beyond maybe what would be like the best legal option. And we really hope that this book can be a useful bridge and will serve as a useful resource for radicals who are working in conversation with and in collaboration with a legal team. It covers such topics such as how to take a movement approach to handling criminal charges. And I would say that's kind of a broad overarching theme throughout the book. How a radical defendant and their lawyer can jointly set legal goals, common mechanisms of repression against radicals and their movements. So in the so-called United States, that looks like, and other places too, but it's about the US, infiltration, grand juries, terrorist enhancements, slap suits, etc. How to navigate plea agreements, in particular, non-cooperating plea agreements. And then how a lawyer can work strategically with a defense committee's political and media campaign, special considerations for high-risk defendants. The end of the book, or actually our website, includes a list of further resources. And there's a lot more that's covered in the book. And one thing that we did while we were writing this book is, in addition to drawing on our own experiences, as Jenny said, working, doing legal support work. We also pulled in a lot of voices from movement attorneys who've been through this in various ways for decades. So the book includes a lot of lessons learned and maybe key points from the voice of those attorneys speaking to their colleagues. And yeah, as we'll talk about more, the book really starts from a couple assumptions. The assumption that as long as people continue to struggle for liberation, we'll continue to see courts acting as a repressive apparatus. And then additionally, we really do believe that attorneys can work kind of on equal footing, not kind of on equal footing with their clients in order to advance these liberatory struggles, though we may have different goal areas, or though we may see things a little bit differently. So we call that taking a movement perspective, just to be concise about it. And I believe Lauren is going to talk a little bit more about what we mean by a movement perspective.
Thanks, Jay. Yeah, so the first thing that I will kind of say in terms of framing a little bit of what Jay was talking about, clients are the boss of their lawyers. Some lawyers kind of forget this sentiment, but a lawyer takes instructions from their clients. And so it's important that as a defendant, that you have the wherewithal to know what you want, and or you have the words to be able to have a conversation with your lawyer. For instance, like once you say, I am not going to snitch. Snitching is off the table because I don't want anybody from the movement to be punished as a result of me being caught in the crosshairs. Once you say that clearly, you have kind of given your lawyer their instructions, and at that point the lawyer can do their ethical duty of advising you on what your options are, and then you can move forward with really trying to craft your defense as best as you can around that movement perspective. So from that perspective, generally speaking, first I would say, like, history repeats itself. And if you don't know your history, you're bound to repeat it. And so making sure that you and your lawyer have both been educated on what kind of repression the movement has faced in the past, what kind of repression is going on currently, and what you might expect, in litigating that particular type of case can be really important. The idea that rather than, I think a lot of lawyers are trained that they are supposed to myopically focus on getting the best deal possible for their individual client. And, I've had a lot of lawyers tell me that to do anything else was unethical, which is totally not true. If the client tells you that that is not their goal and that is not what they want, and you're, somewhat confident that they know and understand the risks of taking a more collective perspective, then it's absolutely ethical for a lawyer to advocate for their client in that larger context. And a collective perspective may mean things like trying to get a global resolution where, maybe my client is the least culpable person in a group, but they agree to kind of get a worse deal so that people that are facing much more serious charges might get a lesser serious deal. I think of during the Green Scare, there was a small group of non-cooperating defendants. And just to define that, non-cooperating means you're not going to snitch, you're not going to inform on others, you're not going to give up information that could harm the larger movement. And one of the defendants, Jonathan Paul, probably could have walked away from that case with a slap on the hand, and he was my client. But there were 3 other non-cooperating defendants that were looking at life plus 1,500 years in prison. And by being able to offer up a global resolution for all of those non-cooperating defendants, they were able to get a much better deal for themselves, even though it probably wasn't the best deal that we could have gotten for Jonathan. So that's sort of an example of how a collective perspective, can sometimes function. I think I defined non-cooperation. And in terms of like the best possible defense, normally I think when we're talking about the best possible defenses, that can differ depending on the goals of the movement or the group of defendants. For instance, I represented a group of individuals that one of their primary goals in taking action was to assert a climate necessity defense in court and to basically try to be able to use that defense with a jury. And when we finally got to trial, there were probably other defenses that we could have asserted that may have actually gotten them out of trouble, may have gotten them, a not guilty verdict. But with their explicit understanding and consent, we chose not to put forward those other defenses so that the court and the jury would be forced to actually utilize the necessity defense and make rulings and findings on it. Otherwise, the court could have found them not guilty for some other reason, and we never would have been able to actually try out that necessity defense. So that's kind of an example of listening to the client, understanding what their goals and interests are, advising them on the risks and benefits of that. But if they, say they want to stand on their head and spit nickels, and you are pretty sure that they understand the risks and benefits of doing that, then to the extent that you're not crossing any ethical lines as a lawyer, it's your job to permit them to assert the defense that they want to. They are the ones on the hot seat. They're the ones whose liberty is at stake. And if they're making knowing and consensual decisions, then, we need to assist that. So, there is no right way to approach charges from a movement perspective. I think really the only pretty solid line in the sand would be with regard to non-cooperation. At the CLDC, we will not work with individuals who choose to cooperate with the state. Our perspective is that as activists and as movement participants, we choose our team. And if you cross a line and are cooperating with the state, you've chosen the state as your team, and you're not allowed to come back to our team. And so we won't compromise our values and our ethics as lawyers. And We will do everything possible to empower people to feel confident in making the decision not to cooperate. It's kind of important to know, though, that like if you're in jail, especially in federal jail, and let's just say a federal public defender walks into your jail cell, they're going to feel like they have a duty to say, the government would like you to cooperate and inform on other people. If you do so, you'll get out of jail. They are required to relay any offer, including an offer of cooperation, to you. And it's your obligation to know and understand your stance on cooperation and very firmly and confidently let that lawyer know that that's off the table for them.
Thanks, Lauren. So about that, I wanted to just back up a little bit and talk a little bit more about the Defendant's Guide, which Jenny already introduced, but I have a copy of right here. So it's important, as Lauren mentioned, when you're working with a lawyer and you're a radical defendant, to have already given some thought to your personal, political, and legal goals. And identifying those can happen through conversations with comrades and friends, but also just a lot of like personal self-reflection. And maybe it's important to start thinking about what those are, or what those might be, before you are facing criminal charges. So a defendant's guide, the defendant's guide really breaks down on what we mean by personal, political, and legal goals, and then talks through some ways of identifying those for yourself. So by personal goals, we mean goals focused on helping a defendant care for themselves and their loved ones. These considerations may include health status, children and other dependents, one's role in organizations or political movements, financial situation, immigration status, etc. So I think about a case. I was a part of the Cece Mcdonald Defense Committee, and I'll be talking about that a little bit more in a second, back in 2011. But one of Cece's political goals was one of her personal goals was to be able to continue for as long as possible, to be able to continue to be connected to her chosen family. So before she was incarcerated, she and a group of other people, relied on each other for financial support, housing, etc. And one of her personal goals in thinking about a case resolution was that she would be able to continue to stay connected to those folks as much as possible, with as much consistency as before, for as long as possible. By political goals, we mean goals created for and focused on the politics and ideas a defendant hopes to advance through the process of fighting their charges, or like advance, outside of the process of fighting their charges, but not be detracted from fighting their charges, if that makes sense. So this larger perspective takes into account broader struggles, the broader movements that this defendant or group of defendants might be a part of. And then by legal goals, we mean goals set about legal strategy that focus on and prioritize legal aspects of the case. So this is maybe what we think of when we talk about your goals in facing criminal charges, whether that's being no convictions, no cooperating pleas, reduced prison time, reduced probation time, etc. Although there's overlap between these three goal areas, they are pretty distinct, and some defendants or groups of defendants may have other additional goal areas to consider as well. So for myself, I'm a pretty logical brain person, so I really do recommend mapping it out, and you can make a Venn diagram like we have, or just another way of conceptualizing it for yourself. But as Lauren said, there's really not any one way to take a movement approach. It doesn't always mean taking your case to trial, and it doesn't always mean, having a media campaign or a political campaign that looks a certain way. though I do think we can learn a lot from drawing on even recent case examples or lessons. But I do think, what was my train of thought? I do think that, you know, where these goal areas intersect is what's going to be right for a particular defendant or group of defendants. And yeah, I wanted to say a little bit more about just some case examples that I've seen and been a part of, where these 3 different goal areas are taken into consideration, and then action is taken in it, like with those in mind. So the first, as I mentioned, was Cece Mcdonald's case. So I was involved in Cece's defense committee, support committee, from its inception in 2011 and through the duration of her prison sentence. Cece Mcdonald is and was in 2011 a Black trans woman who lives here in so-called Minneapolis, who was charged with murder after surviving an attack by white supremacists outside of a bar on East Lake Street in South Minneapolis. So she was the only one initially, she was the only one charged during that altercation. And when we first started organizing around her case, she was facing, I don't remember, concurrently, like quite a lot of prison time. And it seemed from a legal perspective, quite likely that she would be convicted the way that the evidence was stacked at that particular time. It did not look good. And her, as I mentioned already, she had this personal goal area of continuing to, you know, be able to stay in connection with her chosen family. She also, as a trans woman, wanted to avoid prison time. A prison is not safe for anyone, but in particular for Black trans women, sentenced to what we knew would be Stillwater men's prison. We're looking at a potentially very dangerous situation for her, one that could be life-threatening. So those were her personal and some overlap about her legal goals. But from a political perspective, she and those of us involved in her defense committee really wanted to highlight the ways in which Cece's story, though horrific, is not unique, and really draw attention to and energy around, you know, opposing the intersection of racism and trans misogyny in courts and in, you know, the criminal system more broadly. So to do that, we as her support crew and chosen family members and biological family members, et cetera, organized a political pressure campaign alongside Cece's work with her lawyer and legal team. Then the political pressure campaign was really directed at the county attorney, Michael Freeman. And what ended up happening was, you know, this grew kind of beyond how our own expectations in the media and internationally, to the point where we really shifted the conversation locally and more broadly nationally around the things that we were hoping to talk about, the role of the police in the intersection of trans misogyny and racism. So what was I going to say about that? So yeah, what I wanted to say was that, so like, while, you know, her legal team, wonderful team of lawyers from the Legal Rights Center, were, you know, thinking about how to bring a defense for her as we were pushing towards trial, we were concurrently, you know, trying to navigate her personal and political goals, to shift this broader narrative, to raise more awareness publicly about her case and other cases like hers, to open up conversations about the role of police and prison within our queer community here locally. And this multi-pronged approach is really what led to a more favorable legal outcome. So Cece ended up kind of on the eve of trial through a series of events that I won't go into right now, accepting a plea. And I think she ended up, with credit for time served, ended up doing something like 16 months. Don't quote me on that. But really that legal outcome was one that was much more favorable than what she was initially looking at without broader political support and broader personal support. And probably more importantly, we really did locally, and I think like nationally and internationally as well, change the way that conversations happen about cases like hers. So that's one. The other, I know I'm talking a lot, but the other case example that I have experience with, and more recently, is the J20 case. And there we're talking about the 239 people who were arrested at an anti-capitalist, anti-fascist march kettled in Washington, D.C. in January of 2017 during Donald Trump's inauguration. Those folks initially were all just charged with one count, I believe, of felony riot, but then later 2 indictments added other people. So maybe it wasn't 239 initially, but added other people, over 200. And folks ended up facing a blanket 7 or maybe 8 property damage charges, conspiracy to riot, assault on a police officer charge, etc. And like Lauren, in her case example earlier, brought up, there were a lot of people whose best legal option in that case, for whom they weren't committing any property destruction. Maybe you joined the march at the end, maybe had, for various reasons, thought that they would walk away from a case like that with a very favorable plea. A lot of people could have just pled out and been done with it. But instead, what happened was folks signed on to, organized around that case and signed on to some principles, some points of unity that basically said that no one was going to, I think like 160 some people signed on to these, maybe more than that, signed on to these points of unity, saying that no one was going to plea out. We were going to push for all of the cases to go to trial until the charges were dropped for every single person. And folks organized around that case for a year until January 2018. The charges were dropped for 129 people, give or take. And then 2 cases went to trial. A series of legal things happened that I won't get into right now. But then ultimately the state ended up dropping the charges for every single person in July of 2018. And that wouldn't have happened if not for all of this thinking and agreeing about what our legal goals were. Folks might have different personal goals, but then focusing really in that particular case on the political goal of ensuring that, this dangerous precedent is not set at the beginning of the Trump administration, that, a mass mobilization can just be kettled, folks at a mass mobilization can be kettled, blanket felony charges despite individual probable cause, and then, a series of convictions. We didn't want that precedent to be set. And so I really, think that that's another example of how this 3-pronged goal setting framework can really be applied. I mean, certainly there's a lot of other pieces that went into that organizing that I'm not mentioning now, but yeah, I really do think that, as radicals, and if you are facing charges as a radical defendant, it's important for you and your comrades to give some consideration to and realize that there's, a lot of different areas to consider before you sit down with your lawyer, or maybe not, the very first thing, but at some point, so that you can clearly articulate to your lawyer, like, I don't care if I get convicted in this, or maybe I care, but what's more important to me is that my co-defendants feel my solidarity, or, that we're able to continue to participate in a media campaign that says XYZ thing about these charges. And then Lauren has already talked about, and can maybe say some more about, then it is a lawyer's job to hear that and respect that and help those clients then figure out what their best legal options will be. So I believe Jenny and Lauren are going to say a little bit more about the decision to pursue a political defense and maybe what that looks like.
Well, Jay, before we dive into that, what I would say about what you just laid out is for CLDC, we kind of assign this to our clients as soon as we agree to take on their case. We ask them before they even meet with us to think about their legal, personal, and political goals. Even if we find even if activists were purposefully engaging in direct action, they may have thought through what the potential consequences, they might have thought through what it would be like to go to jail, but more often than not, we find that they have not actually thought through these types of questions. And from the attorney perspective, not only is this a helpful conversation when you're starting a new case to see, does the person want the case over with fast? They want a plea bargain. They want to be cut loose from the legal system as soon as possible. That might be their goal. Or, maybe they're in school and they're going to be getting a professional license. And so convictions on their record is going to be one of the top goals. So it really helps frame the defense for a lawyer early on to understand what is on the table or not on the table with regard to plea negotiations or not. The other thing from the lawyer perspective, sometimes when we assign this to clients and we sit down and start talking about them, we realize that right off the bat, this client has really unrealistic goals or understandings around what is possible in their case or not. And so to be able to have a more realistic conversation oh, you've been charged with murder, you're probably not getting community service hours for that. That's just kind of an exaggerated example. But, sometimes things like that will happen where it allows you to sort of better align reality with this person's understanding at an early stage of the case. So I find it to be a really valuable exercise for both client and lawyer as early in the case as possible. And sometimes these things change over time. Sometimes the legal goals may change because all of a sudden evidence comes out that shows the cop doctored evidence, so now that's going to become a legal goal. So just because you set these goals at the very beginning of the case doesn't mean that they can't change or, evolve throughout the case.
Thanks, Lauren. Lauren, do you, or I can, or Jenny, want to say a little bit more about what it means to mount a political defense, or some considerations for doing so? Why folks might choose to use the fact that they're facing charges to highlight certain political priorities?
Sure. Yeah. I mean, again, this is not a one size fits all, rubric either. There can be times and places where people are facing charges where it may be in their best interests to try to keep the politics on the down low and to just try to get through the legal process with the least consequences possible. If that is your client's goal, and, if the lawyer is telling you you have been assigned to the most conservative lock 'em up judge in the country, sometimes circumstances are going to warrant all sorts of different, evaluations to take place. But once those things have been laid out pretty clearly, the decision to mount or not mount a political defense, obviously the ultimate decision for that is with the client. Like I mentioned before, the client is the boss. The client or the defendant is the one that may or may not go to jail. So, ultimately it really is their decision to make. But political defenses can be all sorts of things. It can be something as simple as incorporating the movement orientation or alignment, the political issues in an opening statement. In the voir dire, you may want to be asking jurors, like for instance, we just did a round of jury trials with climate necessity defense, including in Minnesota, but also in Montana, North Dakota, and Northwestern Washington. These were really conservative areas that were home to the fossil fuel industry. And we're representing some white older folks that were not necessarily from those areas to talk about global climate change and catastrophic climate change. And so in that case, it was an overt and primary goal to put the politics of the case into the case as much as possible. As I mentioned, to the extent that we were going to be asserting this climate necessity defense as the defense for the criminal charges. And these folks were facing felony charges as well, definitely looking at 10 years in prison if they were convicted of things. But, so it included things like pre-trial media, doing public speaking, bringing solidarity and awareness to the larger movement even before the trial started. And then in voir dire, we were asking people, do you believe in climate change? And many of them would answer, climate change is a hoax perpetuated by the Chinese. Literally, like you start having that conversation at the earliest stage of picking a jury. With the necessity defense, and in most defenses, the right of a defendant to testify on their own behalf is solely the defendant's. A defendant never has to testify, but in political cases, very often the defendant is going to testify, even though mainstream lawyers think that that's perilous and oftentimes not a good idea, because then the DA gets up and cross-examines you and maybe asks you things that, normal lawyers may be uncomfortable with. But from a political perspective, for a defendant to be able to take the stand, look those jurors in the eye and tell them why they risked their liberty for this particular cause, to be able to explain the politics of the case, and the movement perspective is often essential. It's why they risked arrest to begin with. And so you don't want to take that away from them unless it is a consensual decision based on, whatever factors may be on the table. And it leads all the way through the rest of the trial. Certainly closing arguments are a time to really explain to jurors what the political importance of this case is and help them to put together the strings and, sort of tie it together. But it doesn't really even stop with the trial. Even if somebody is going to take a plea deal, all defendants have a right of elocution upon sentencing. And that means that the defendant has a right to make a statement on their own behalf. And a lot of lawyers are going to tell their client, just get up there, put your head down, apologize, take responsibility, and say you'll never do it again. But that is often very contrary to a political defendant's stance or perspective. And it's really disempowering for a lawyer to tell a political client that, you're about to be punished and you're going to be benched, from doing activism for a while, and you're going to go out with like a whimper and your head down. You obviously need to tell your client that, like, putting the politics of the case into the courtroom, and certainly putting the politics of what you did at sentencing, the judge has absolute discretion on punishment, and they don't make their decision on what punishment you're going to get until after you make that statement. So there certainly can be things that come out of your mouth that are going to piss the judge off, and you're going to get worse or more punishment. There can also be things that you can say that will show the judge that, unlike some of the defendants that they see on a day-to-day basis, the crime you committed was done in the public interest, was done for a cause greater than yourself. And that altruistic aspect of political cases is uncommon in a lot of courtrooms and, uncommon for a lot of judges to see. And in my 24 years of experience, more often than not, when I have my clients make statements, we've even done PowerPoint presentations with photos and videos. Oftentimes you can tell that the judges are appreciative of getting a better sense of who this person is, why they did what they did, and for what purposes. Sometimes the judge will hate you for it and has the opposite political belief, but a lot of times, they may actually agree with you more than they would ever let on. And then finally, what I would say, I want to just kind of point out for the lawyers that are watching this, in the criminal context, at the end of the case, when sentencing is happening, oftentimes the issue of victim restitution comes up. And victim restitution is different than like fines to the court. Victim restitution literally means that the court will impose an order on the defendant that orders them to pay money to the quote unquote victim, which in a lot of cases is literally your adversary. In those pipeline cases I was mentioning, the pipeline company would seek thousands and thousands of dollars in restitution because their pipeline got shut down for a few hours. And if the court ruled in their favor, my client, who just risked 10 years in prison to stop that pipeline, would be forced to give up the movement's money or their own money to the corporation that they're fighting. And so restitution is a huge issue. Here at the CLDC, we probably spend as much or more time fighting restitution for our clients than the trial itself. And this is really important for movement precedent. We do not want activists getting hit with heavy restitution amounts, because then the next person that goes through the gauntlet, the courts are going to be expecting to do something similar to them. So it's really, really important that we fight it, not only for the strength of the movement, but certainly for that individual defendant. The last thing that somebody wants to do is have to cough up $30,000 to a pipeline company because they locked down to the pipeline for a few hours and made it shut down. So, that's just kind of like a few examples of how political defenses can work. The Chicago 7 is a pretty classic example. And now there's, a brand new movie that people probably have seen. It's a really good example of taking political defenses to the utmost. In that case, at least, 2 lawyers were threatened with contempt of court and were jailed for pushing on a legal system that we all know has grave problems back then as well as now. We all can register injustice. It takes a pretty brave lawyer to, go to jail themselves, potentially have their bar license threatened, to really expose and push on that unjust system with their client. But there are definitely cases where that happens and where that can be a thing, including some cases pretty recently where that has happened. Obviously, again, there has to be consent on all parties before that is engaged. But, sometimes the deck is stacked so far against a defendant that you're not going to get a fair trial and you're going to get convicted. And so at that point, it's almost more important to expose that than to worry about whether or not you're going to be able to grovel a few crumbs, toward maybe a less severe punishment. I think of the Stephen Donziger case, which is, he's a human rights lawyer that was part of a legal team that sued Chevron and won $9.5 billion in the Ecuadorian courts on behalf of indigenous and campesino people living in the Amazon. And Chevron didn't take too kindly to a $9.5 billion judgment. And they and their law firm basically vowed to basically, like, you know, keep that case, fight them. I think they said fight them till hell freezes over, and then to take it out on the ice, you know, I think was literally a quote from them. And throughout the whole litigation process, it was really overt that the judge and Chevron and its law firms were all kind of like in cahoots with each other. And so when Donziger was prosecuted in federal court, the U.S. Attorney's Office actually refused to file charges against him. And so the judge appointed a private prosecutor who worked for a law firm that also represented Chevron. There was they took away the right to a jury trial. So it was literally that judge and the Chevron law firm prosecuting him together. I mean, he's screwed, basically. So in that case, your hands are tied in a lot of different ways. But, for him, it was incredibly important to make sure that the focus stayed on the fact that Chevron was doing all of this in order to try and draw attention away from the fact that they had a $9.5 billion judgment that they were supposed to pay for devastating the Amazon and killing a bunch of people who lived there. And so refocusing the case on Chevron and its crimes and the collusion between their lawyers and the legal system was more important than trying to render a not guilty finding by a judge that was just never going to do that. So those can be some examples of how political defenses can operate. And then the final thing that I'll mention, and I'll turn it over to Jenny. A lot of times in cases, people will ask me, should we do a call-in to the prosecutor or to the judge or to someone demanding that the charges against this person be dropped? It's a very common tactic that support committees will engage in part because it gives people something to do. There's sometimes not a whole lot that people can do while someone is being prosecuted, but to make a call to a DA's office and say, drop the charges against so-and-so, is at least something. And it certainly is annoying to the DA's office to have to answer all of those calls. But in my experience, it has not often been successful in actually getting the goods for the person that's being prosecuted. And I think people just need to be aware that when you are thinking about that as a tactic, number one, you need the knowing and consensual approval of all the defendants that may be impacted by that tactic. Because in my experience, more often than not, it pisses the DA off and all of a sudden you've got charges added or plea bargains are pulled because they are pissed off at being antagonized. In the worst case circumstances, we've even seen new charges for like coercing state actors being filed against the defendants, even though, they didn't necessarily make any of the calls or even necessarily advocate for that as a tactic. But, it is something. And, I do recall that there have been some rare circumstances where that as a tactic, did in some way impact plea bargaining or continued prosecution of a case. The elected DA is an elected person. And so sometimes there is political pressure that can come to bear. There are different pinch points that can be impactful on a prosecution, especially a federal prosecution, going up the chain of command in the Department of Justice can sometimes be impactful, calling for investigations for individual police officers or whole police departments can sometimes create a circumstance where They'd rather just let the case go than have the skeletons exposed in the closet. In the Green Scare, part of the reason that the government finally offered a non-cooperation plea deal to our clients was because we had filed this giant motion demanding that they turn over NSA wiretap info. And they, filed back saying, screw you, we'll never give that to you. But the judge actually ruled in our favor and said, yeah, bring in the FBI agents, let's put them on the stand, and that's valid testimony. And as soon as the judge ruled that way, all of a sudden this non-cooperation deal was possible, from the U.S. Attorney's Office, because they would rather give that non-cooperation deal than have to expose the inner workings of their spy mechanisms to the public. So there can be all sorts of things like that that can play into a political defense.
Cool. I wanted to, Jenny, and maybe you have words to say too, but I wanted to jump and just kind of piggyback off of something you were saying, Lauren, about call-ins as a tactic. I know, I've been a part of numerous legal defense crews over the years, and also just have had a lot of informal conversations with folks about trying out different tactics and other ideas. And as the Tilted Skills Collective, often will have calls or meetings with folks who are facing charges, and they're thinking through what to do and where to apply pressure. And I guess I've never seen a call-in campaign on its own result in a more favorable plea or a more favorable legal outcome, but I have seen calling campaigns be a part of a broader outside the courtroom campaign or struggle that has made an impact on what happens in the courtroom. So I think just making that distinction again, that there's not a cookie cutter way of moving through facing legal charges, and also to just, be really, if you are a part of a defense committee or a support committee, or you yourself are facing charges and you're thinking through your options politically, just being really, if you can, discerning about what your context is, and also, again, thinking through and having conversations about what other people have done, and maybe think about what steps are going to lead to the outcomes that you want in your specific case. So I just wanted to add that as well. And then Jenny, you can talk if you want to.
Thanks. I don't know if I have too much to add. You both did a great job. I think the only thing that was sort of coming to my mind as Lauren was talking, and I know she definitely covered this a lot, is I think when we're talking about political defenses, that's one of the areas where there is sometimes a fair amount of legal risk. And I think that that's also a point at which there's often a lot of friction between attorneys and clients as far as what the attorney might think is best for their client and what the client actually wants to do. And I wish that everybody had the amazing representation that they get with Lauren and with the CLDC. Unfortunately, we all know that's not the case. And so I would just really encourage people when they're in that kind of situation. That's why it's so important to have those conversations with attorneys early on about what your goals are and how you want to pursue them, and what's okay for you to do and what's not okay for you to do when you're moving from, a movement perspective. And also for attorneys in those situations to feel okay about reaching out to Lauren, reaching out to the CLDC, reaching out to people who have experience with these kinds of cases and these kinds of defenses, to get a feel for how it goes and what might be a good strategy. Because in my experience, folks are really excited to share their experience with people and to help build movements in that way. So that's the only thing I would add.
Well, thanks, Jenny. Well, the bulk of what Representing Radicals focuses on is the role of an attorney representing radical clients. And I think we've talked about this quite a great deal. So I think I'll just do a bit of summarizing, and then you all can add things if you want to. But we really wrote our book from the assumption that attorneys can work with all of their clients, and in this book we're talking about radicals who are facing criminal charges, on more equal footing. That really, it is the attorney's job, as Lauren said, and as we all know probably, to respect the desires and principles of their client. Attorneys can advise their clients and their client defense committee, if that's applicable, about things like media strategy or political strategy. But ultimately, it is that defendant who gets the final say. Blah, blah, blah. So for lawyers, I think this often, just like kind of at baseline, looks like demystifying the legal system. The criminal legal system is designed to force a guilty plea. It's designed to be confusing and dehumanizing and isolating, etc. And so, legal strategy aside, at baseline, a lawyer's job is to be able to explain, the court process and, what legal options may exist. Maybe, as Lauren mentioned, give a little bit of a reality check for what legal outcomes are likely, and make sure that their client is consenting to whatever path is taken. We really do think that radicals facing criminal charges, as well as their comrades and supporters, do bring a lot of skills to the table. So I know not all lawyers are Lauren, and oftentimes attorneys may bristle at the idea of, co-defendants talking to each other, or, defendants having political support around their case outside of, their relationship with their attorney. And I really do think that there are ways that attorneys can navigate a defense committee or co-defendants while still adhering to their ethical obligations. And there are some benefits to working with radical clients just in general. So our book talks about how radical clients may have, prior experience fighting charges, if not their own, then those of other people. They may know about, or, have experience, be part of a network of folks who've faced criminal charges in the past, and be able to, draw upon those lessons in thinking about how they're going to pursue with their case. And even if they're facing charges for the first time and have no previous knowledge of how to navigate the criminal legal system, they may have, and probably do have, a strong principles and a political analysis that's going to help regarding the police and prison and corporations and the government, et cetera, that's going to help guide them through, what's going to be best for them. And as an attorney, I do think that those are strengths. Or I'm not an attorney, as an attorney working with clients in that who are radicals, I really do think that those are strengths, and that working with someone of that demographic, of radical client, really can make your job easier. Jenny, do you want to say anything more about that? Okay.
I have a couple of things to add to that.
Yeah, please.
So first, I would say for lawyers, this is not like super exciting or sexy, but I do a lot of trainings on ethics for lawyers, because the more radical or political the case, the more careful you have to be about where the line is drawn for lawyer ethics rules. And especially because we do cases all over the country, one of the first things that I do is the boring, read all the ethics rules, read the ethics opinions, particularly regarding things like pretrial publicity or decorum in a different court. You don't want to give the bad guys an easy way to mess with you and to take you out of the game. Especially as a left lawyer, activist lawyer, I know there aren't too many of us. And so there is certainly a larger target on my back than, a mainstream divorce lawyer that is a dime a dozen. So I have to be extra careful to not make it easy on the state to take me out of the game. And knowing the ethics rules and being really confident in where the line is drawn is really, really important. The second thing that I would say to what Jay was mentioning, it is our job to explain the charges, explain the legal process, explain, the maximum punishment, the minimum punishment, the most likely, et cetera, et cetera. But it's also really important for lawyers to use plain English in explaining this. I especially see newer lawyers that maybe don't actually have a super strong understanding of some of the concepts. They will use big vocabulary words to make themselves look like a lawyer. And I feel like it's our job to be a translator. And your client can't knowingly consent to things if they're not actually understanding it. And especially in the legal context where people are already feeling intimidated and out of their comfort zone, don't expect someone to ask you to define something or further explain it. More often than not, I think they're just going to be quiet and not understand it because they don't want to look stupid. And so you should never rely on your client to ask for further clarification or explanation. If you need to use a legal term because it's important to their understanding, you should just automatically define it in plain English after you use the term. And then finally, Jay was mentioning group representation or working with legal collectives. From the legal perspective, we call these joint defense agreements, and they are ethical, they are legal, and it's where multiple lawyers and multiple defendants work as a brain trust, that we put our heads together as a group to come up with the best legal defenses, the best legal motions, and to be able to act in solidarity. When we talked about collective defenses before, this is the most standard and straightforward way to be able to do that, because by entering into a joint defense agreement, you put that attorney-client bubble around the whole group, and that group can include legal workers. It can include non-lawyer, non-defendant people who agree to strict confidentiality and to come into that attorney-client bubble. And then they are protected from being forced to disclose information that they've learned within that bubble. So it can be really helpful, especially if you're working in a community where there may also be threats or concerns with regard to grand juries. To have legal workers within your attorney-client bubble will give them an additional way to potentially resist a grand jury in the event that that would happen. So I just wanted to add those little pieces.
Thank you. And we have a sample joint representation agreement on our website under the resources tab. We're getting toward the end of our presentation, but I don't know, Lauren or Jenny or myself can talk a little bit more about, I feel like we've hit on a lot of this already, maybe just to get to highlight the importance of having good boundaries, and as an attorney being really clear with your client about where those lines are, and then for the client also being really clear with your attorney and your supporters about your own, what you want to do, what you want to see happen. And that all comes from being able to set those boundaries for yourself, comes from having time to and space to reflect on those goal areas in the beginning that we mentioned in the beginning.
Can I just add one little thing to check assumptions? Because we're doing this right now with line 3 in Minnesota. Check assumptions also means, as a lawyer, a good lawyer is going to do some research on the movement that their client is involved in, doing your own recon to understand the movement and maybe some of its ideology. It also means, to not be a jackass, especially pronouns, for instance. There have been some elder attorneys that scoff and are just super disrespectful with regard to things that they may view as idiosyncrasies of their client or the client group. It's hard to keep up and be super savvy to the changing social milieu that radical activists perpetuate. But in order to be an excellent lawyer, and in order to be respectful of the client and the movement that they are fighting for, it is your job to be open to being educated about those things, and you don't have to be an expert in everything. Don't act like a daddy, and just, have an open mind and be humble, and be willing to learn.
Mhm. Jenny or Lauren, did you want to add anything more about attorney-client collaboration? No? Okay, that's the end of our slideshow. So I do see that there are some questions in the Q&A, and I invite other participants to ask questions there, and we will take a little bit of time, not a lot of time, a little bit of time going through those questions. And I'm not a Zoom person, so someone else want to facilitate?
Yeah, I was going to facilitate them. So the first question is for all of us, I think. What has motivated you folks to do anti-repression work for so many years? What role do you see that playing within anarchist or left spaces more broadly? And says, thanks for your thoughts tonight. So I'll start. For me, I went into being a lawyer because I come from this movement, and I recognized that it was a needed, that movement aligned lawyers were really needed. There weren't very many of them, and it was just a niche that I had capacity to fill and wanted to fill. I always tell my law clerks, there's joy in being useful. And I feel like the reason that I've been able to do this for so many years, 24 as a lawyer and more than that as an activist beforehand, is because, it is just really gratifying to feel like you are using your brain for the best purpose that the movement needs and wants. So being useful, I think, is integral to longevity in this struggle. And I would say, part of the role that I now find myself filling is making sure that newer folks to the movement know their history. Because the FBI and the state's playbooks really haven't changed that much. Every 10 years or so, they kind of repeat the same crap. And because it's a whole new group of people, folks act like it's the first time a grand jury has ever been convened, And so I feel like there really is a role to make sure that people who are new to the movement and younger people really are grounded in the past. And it's not because we like to tell glory stories. It's because it's very likely that you will see those stories repeating themselves. And if you are able to spot that story playing out again, hopefully we can change the way that, we can do something different so it doesn't just repeat itself in the same way, oftentimes causing harm. Check.
Cool. I can go. I got started in this kind of work because I was involved in movements in the early 2000s, and I started seeing people that I loved and cared about catching pretty serious charges. And I got involved in their specific support campaigns. And then that just sort of, tumbled into people calling us, asking, about how a certain procedure would go, or, my friend just got arrested, what do I do? And it kind of goes back to what I said at the very beginning, where once you've been through this, sometimes it feels a little bit easier to talk to people about here's what's happening, here's what you can maybe expect in the future, to help people sort of take a step back and figure out how to look at the bigger picture. And then also just support people on a really personal level. This is hard stuff, and it affects people, it affects their loved ones. And I think what Lauren said about feeling useful and doing important work was really big for me. It felt like I was making a difference for the folks that I knew personally that were inside, but also just connecting with other people's loved ones. People on the outside who were supporting people inside felt really important to me. And unfortunately, it was a terrible way to get involved in the work, but I'm glad that I did. And I think it's really important. And unfortunately, it's going to continue to be important. So,
yeah. Thanks, Jenny. Just for the sake of time, I'll keep my answer brief. I think I became involved in anti-repression and legal support work due to loved ones facing charges, people I care about facing charges. And also I think a lot of what Lauren had mentioned already of like not wanting to see people reinvent the wheel every single time, you know, feeling like anti-repression work or legal support work, whatever you want to call it, the ability to navigate criminal charges is a crucial piece of anarchist or leftist movement infrastructure. And it feels important to me that we not lose that every 5 or 10 years. Check. And more I could say about the role I see it playing more broadly, but for the sake of time, check.
So Sam says, thanks for an amazing training. I'm a lawyer in Georgia. First, have you worked on cases in Georgia or the South? And if so, what are they? For me, we just got done doing a case in Arizona. I did a bunch of cases in Texas with regard to tar sands blockades and Trans-Canada. We had a couple cases in Florida. I'm not sure. I mean, we actually had a slap suit that started off in Georgia, but we got it moved to the Northern District of California, which seemed a better option. Jenny, any Southern work for y'all?
I don't think that I do have any experience in the South, actually. I'm imagining it's being an interesting place to do this work.
Most of my experience has been here in so-called Minnesota, and then being involved with the J20 case, which is involved anarchists and people who are not anarchists from all over the country. I know as a Tilted Skills Collective, we've been a part of numerous, informal conversations with folks facing charges for a variety of reasons from various states in the South, but I've never spent considerable time living in the South, and no, don't have a lot of experience navigating the courts there, but I would be interested on a personal level connecting with folks who are doing that work. And I know that there are people doing that work in the South. Mm-hmm.
Yeah. And then the second part of their question is, do you ever collaborate with other organizations on dissent work? And for CLDC, I would say all the time. Not only are we always trying to put together joint defense groups and finding local attorneys to pro hoc vice with us on cases, but, there is strength in numbers and there is protection in numbers. And so we are constantly collaborating with all sorts of left of center orgs to do this work. Tilted Scales.
Jenny, you want to do it or do you want me to? Tilted Scales is open to collaborating on stuff. And I think it just sort of depends on, we're a small collective of folks with a lot of other things going on. So I think to some extent, the collaboration depends on what the project is and our own capacity, but certainly open to having conversations about how we can bring our skills together.
The next question, it's not really a question. It says, the terrorism charges override standard criminal rules and procedures. And what I would say to that is, in the federal system, there's actually like over 115 different terrorism charges and or references to that word. So it's a really ambiguous word that is sort of one of those boogeyman words. During the 50s, it was called communist. For a long time, anarchist was also in that, sort of boogeyman category. Now the feds, will call something terrorist. And I know for a long time we were kind of pushing back on that by saying like, actually the terrorists are the ones that are, destroying the planet, not the ones that are fighting for it. But with regard to overriding standard criminal rules and procedures, what I would say is, there is still a constitution, even in the face of the Patriot Act and the Trump regime and all these other things. You saw the ACLU and all sorts of other organizations constantly filing lawsuits to say there is actually a bottom line here. There is actually a hard stop, which is, this somewhat weak, constitutional floor. And so, whether it's Guantanamo, whether it's critical energy infrastructure, or, any of the other types of like quote unquote terrorist type charges, there's always a way to push back on that. And we, can hold them to the set of rules that they actually wrote and implemented. And so, I would respectfully, slightly disagree with that as a statement. Jay or Jenny, anything to add to that?
You got it, Lauren.
Yeah, I think what you said is great. The only thing I would add that just sort of popped into my mind, and maybe it's tangential, but often I know what I've seen is not terrorism charges necessarily, but terrorism enhancements, which come on at somebody's sentencing. So like maybe somebody's just charged with conspiracy to commit arson or conspiracy to riot or conspiracy to, choose your own adventure. But so a case can go through and there's, no terrorism charge, but then when somebody is sentenced, they slap on a sentencing enhancement, which can sometimes add, years and years to a person's sentence. And so that's definitely something people should be thinking about as they're strategizing and thinking about their goals for their case, because that can definitely play a big part in it, further down the road.
Yeah.
And even be thinking about that as you're thinking about your tactics too.
It's
like in the Green Scare, part of the reason that the terrorist enhancement was imposed on them is because they left behind written communiques that stated the reasons that they did their actions, including trying to change the government's position on a political issue, which is coercing the government, which is a basis of the terrorist enhancement. So folks should definitely be familiar with all of those things before they, allegedly go break the law.
We saw terrorist enhancements here in 2008 in the lead up to the Republican National Convention protests as well. Folks who were organizing things that definitely don't fit under my definition of terrorism, like childcare and free food and bikes, etc. Were all charged with got terrorist enhancements added to conspiracy to riot, and thinking about getting that enhancement dropped was, really part of the legal and political strategizing that went into fighting those charges.
And then the last question is, what are y'all's opinions on the movement lawyering trainings that happen at Yale and other elite institutions, Reb Law Conference, for example? Do you think it's possible for people who benefit from class struggle to actually be, quote, true movement lawyers? And I will tell you that I have spoken at Reb Law multiple times on the Animal Enterprise Terrorism Act and all sorts of other things. And I would say, I would go back to that other answer that I gave, which is, we joke about there being varying degrees of black belt radical lawyer. There's like, it's sort of like veganism, do you eat honey? Do you wear silk? There's all these different levels of being vegan. And I think there are different levels of being, quote unquote, true movement lawyers. But, going back to what I said at the beginning, we all have to pick a team. And there's either the side that is fighting the state and, trying to reduce suffering and to make the world a better place. And then there are those that are working for the state to repress others, to put people in cages, to do all of those horrible things. And I don't think that we can expect everybody to be super duper black belt movement lawyer. But bringing them along and making them better than not, and having them stand in solidarity with us, especially for myself, I will say, sometimes I feel targeted because of the legal work that I do, and knowing that I can call upon a bunch of other lawyers that, maybe don't share all of my politics, but would stand up for me if the state were to come for me, is part of the reason that I can do this work every day. And sort of like that Martin Niemöller quote, I think it is important for us. It's funny because I just read this book called The Federalist Society by Michael Avery. And in it, they're explaining the Federalist Society and the reason it became so strong and powerful as an institution, as a legal institution, is because they have done what's called a big tent, where it doesn't really matter who you sleep with, what your gender pronoun is, as long as you are big tent down for the primary goals of the Federalist Society, they'll take you as a member. And as the left, we've had a lot of problems with like being so siloed and in little niche groups where if somebody isn't, a super black belt vegan, using the right words and the proper dress code, that they are somehow like unworthy and, are tossed out of our tent, is part of the reason why, we have not been able to mobilize power perhaps in the same way as the right has been able to. That would be my quick answer.
Thanks, Lauren.
Yeah, I agree with that 100%. And I think, maybe our sort of implicit response to that question is just our book, right? Like if we didn't think that we could like speak to these lawyers on some level, we wouldn't have written the book. And I think that, that's what we hope to do is like Lauren said, not everybody has to be black belt, radical, vegan lawyer. But we're hoping that the book can act as sort of a bridge for folks who are not that, because most lawyers are not that. And we want them to be able to work with radical clients and figure out a way, like we said, to advance movements together instead of sort of always being at odds with each other.
Yeah. I would add, I agree with what Jenny and Lauren already said. I would add that I think there's like a, a broader conversation to be had about like what role courts play in making a better world, or, opposing the bad things in the one that we're in right now. And also I think that, as anarchists and folks, fighting for liberation, I do think that it's important that we develop infrastructure and have allies for navigating criminal charges. And yeah, exactly. Our book is a response to, I think, what we perceive to be a gap in that. Mm-hmm.
Yeah, and just remember that language really does matter, for lawyers, like we train all of our law clerks and legal workers to call it the criminal punishment system, not the criminal justice system. And sometimes just those little words, especially coming out of lawyer mouth, can really start to change conversations around, some of the systemic problems and conflicts from being left and a lawyer or a legal worker. There are definitely contradictions, but, I think for many of us, when we are able to like get into the jails and give somebody a hug that, is afraid and is caught up in that system, it kind of makes the 3 years of law school and that bar license, all the more valuable. So that's my plug for future law students out there.
Well, thank you. Just our final slide, I just want to highlight some resources, our books that we mentioned. We also have on our website available a free zine. That's just chapter 2 of the Defendant's Guide that you're welcome to download and distribute as you wish. And then again, at the beginning of our slideshow, let's see if I can toggle back. I cannot. We have, what I meant to say was you're welcome to check out our website and contact us at the Tilted Skills Collective, and I'm sure CLDC, with additional thoughts and questions.
Yeah, and so, for people that have the means, buy several copies of this book and give it as gifts to any law students, or if there are lawyers in your community that have been willing to maybe engage in some low bono or pro bono, and you wish that maybe they had a few more skills on board, this is a perfect gift. That and some vegan zucchini muffins or something like that can really win over a free lawyer if you are trying to build a stable of that. Because I kind of get the feeling that with catastrophic climate change, there's going to be a growing need for activist lawyers. And like I said, there aren't that many of us out there. So we really do need to build our ranks. And a guide like this, can sometimes really help lawyers to know that, engaging in politics and the law is okay. In fact, it's actually strongly encouraged.
Great. Thank you. And I don't know how to do this, so it'd be awesome if someone else could share in the chat or in the Q&A just a link to AK's website so folks can just click it to order a book. Is someone going to do that?
I would if I knew it, but.
Okay. Cool. Well, you can buy this book from AK Press's website. And thank you everyone for taking the time on your Sunday to watch this presentation. And thank you to AK and to IAS for publishing our book, and to Lauren for parting us with her smart words.
Thanks for having me.